Good morning. I think it's still time to say good morning. So, good morning. Thank you for coming. Welcome to this panel towards the Digital Fairness Act, how to better protect people from harmful commercial practices online. This panel is organized by BEOC, the European Consumer Organization. We are representing 45 national consumer organizations from 31 European countries, including EU and non-EU countries. My name is Urs Buske. I'm Senior Legal Officer at BEOC. And this morning, I'm joined by 4 wonderful speakers, which I would like to introduce to you now. So, to my left, we have Maria Murtu-Canelopoulos. She is Head of Unit for Consumer Law at the European Commission's Directorate General for Justice and Consumers. And we are particularly delighted to have her because it's actually her unit that is preparing the Digital Fairness Act. And next to her, we have Simona de Heer. She is a tech policy advisor for Dutch MEP Kim van Spaantak, and she has worked on various important files, such as the AI Act and the European Parliament's report on addictive design. Welcome. Then we have Ilya Bruggeman. He is Director for Digital Single Market and Consumer Policy at Eurocommerce, which is the principal European organization representing retail and the wholesale sector. And at the far end of the panel, we have Fridtjof Michalsen. He is EU Policy Officer at UFC Que Choisir, the French Federation of Consumer Organization, and he's mainly working on digital consumer policy. As the title of our panel suggests, we would like to discuss with our speakers, but also with you, the audience, how digital fairness could be improved. And as I guess most of you know, the European Commission has concluded the so-called Digital Fairness Fitness Check in October last year and has announced to develop a Digital Fairness Act during this mandate. And against this background, we would like to use today's panel to discuss the following guiding questions. First of all, what are the unfair commercial practices that people face online? Why are existing EU rules not enough to tackle them? How could the announced Digital Fairness Act remedy the shortcomings in EU law, and how enforcement of existing rules could also be improved to contribute to better protection of consumers. And before we start with our panel discussion, I would like to give a brief outline of the structure that we have visited. So we have roughly 75 minutes, and during the first, say, 20-25 minutes, I would like to do 2 rounds of questions with our speakers. And during the first round, I would like to focus maybe more on the Digital Fairness Fitness Check and its main finding and to discuss them. And during the second round, we would like to discuss the way forward and how enforcement could be improved and how the Digital Fairness Act can address the problems that we identify in the first round. And then we'll try to have a Q&A session of, let's say, 30 minutes. And then I give our speakers the floor again for their concluding remarks. So if that's okay with you, then let's jump straight into our questions. And my first question goes to you, Murtu. So in October last year, the Commission has published the results of its Digital Fairness Fitness Check on consumer law. And in this fitness check, the Commission has assessed whether EU consumer law sufficiently protects consumers against harmful commercial practices, such as dark patterns, addictive design, influencer marketing, and unfair personalization. Murtu, could you please, as a sort of introduction to our discussion, give us a little overview of the main findings of the fitness check report? Thank you.
Very gladly. Thank you, Urs. I don't know if you can hear me and if the microphone works. Very good. First of all, before I start giving you a flavor of the fitness check results, I want to say a big thank you to you, Urs, and to BEOC for inviting us and for also drawing attention to the point of digital fairness in the context of today's event. It is still early days, but it is also in many ways a perfect timing to have this discussion because we are about to launch a very broad consultation to gather further data and make sure we get the balance right in this Digital Fairness Act. As you mentioned, we are not starting from scratch. In October, we published a very thorough evaluation of 3 of our core consumer law directives, focusing on consumer rights, on unfair commercial practices, and on unfair contract terms, checking whether they remain fit for the digital age. Now, the results in themselves are not surprising because pretty much every evaluation ends up with the same conclusion. Yes, the directives are fit for purpose, they are producing good results in terms of consumer protection, but at the same time there is more to be done, and technological progress is in many respects outpacing these rules when it comes to their concrete application and enforcement in the complex digital environment. So under this broad umbrella, perhaps I can draw a little bit your attention to some of the key findings in the areas that you mentioned. I'm sure that for the audience here, these areas are not new. It's what you deal with every day. I am also aware that several of these aspects are already covered to an extent from different perspectives by already existing legislation in other fields. For us, the entry point is really consumer law and making sure that this horizontal safety net that applies to all types of traders, to virtually all business-to-consumer transactions, and is technologically neutral, remains robust, remains fit, remains modern, and can respond to consumers' need in the digital age. So when it comes to dark patterns, our fitness check showed that these remain a major issue for consumers online. We're talking about manipulative techniques that guide consumers through interface design or other methods to making choices that they don't actually intend or fully comprehend. 60 to 66% of consumers in the study supporting the fitness check, for example, reported noticing these scarcity messages, creating an artificial pressure to make a fast purchase decision. 42% experienced a situation where they clicked a button, they made a choice, but the choice ended up being something very different than what they had initially thought they would be making by choosing that option. And more broadly, we have a wide evidence base that shows that dark patterns remain really widespread. Some of our studies really put the number of websites that deploy at least one such dark pattern amongst the websites that are most frequently used by consumers to over 90%. So clearly there is scope for clarification and improvement there. When it comes to addictive design, similarly, we had over 30% of consumers reporting that they spent more time or more money than they wish to because of features that are very familiar to us, like automatic play of videos, infinite scrolling, rewards for staying connected longer than you intended, or even penalties in case you log off or don't visit the app in regular intervals. We also looked into problems with influencer marketing, and there as well, we noticed that despite several attempts to regulate, clarify the regulatory landscape around influencer marketing, almost half of consumers still report that it is not always clear to them whether the content that is promoted by influencers is actually paid content or not. Coming to unfair personalization practices, and there I want to really underline the word unfair. We have also very high numbers of consumers still reporting that they are concerned about the way their data is collected and used in an online environment, and more specifically for marketing purposes. We had 37% of consumers going one step further and saying that they actually feel that these marketing techniques imply that the company in question has a knowledge of their personal vulnerabilities, elements about their personal situation that are used then for commercial purposes. Finally, one element that was not yet mentioned, but it also comes out clearly from the findings of the fitness check, are issues with digital content, digital contracts and subscriptions. There we have 40% of consumers saying that the process for canceling a subscription is exceedingly difficult, and almost 30% saying that they have experienced a situation where a free trial, what they thought was a free trial, gets automatically extended, they get charged, and so on. So these are problems that are very real. The fitness check estimates that they lead to a significant consumer detriment of close to 8 billion euros per year. The fitness check also points to the fact that younger consumer groups are particularly exposed to these types of techniques and suffer an even greater detriment than other age groups. And what we also saw is that the financial detriment, which is what I'm referring to through this close to 8 billion figure, 7.9 to be exact, is only one side of the coin. There is also significant psychological detriment to the overall well-being. We had over 80% of respondents indicating that they experienced high levels of distress linked to such problems that have to do with dark patterns, addictive design, and so on. So it's quite serious. Now, how we will use it, what we take away from these findings, and how we seek to take them into account when designing the way forward in the Digital Fairness Act. First of all, it's clear to us that despite the regulatory framework that is already there and is quite comprehensive, there is a need, there remain gaps and areas of legal certainty that we need to address to tackle these harmful and problematic practices. It is also an opportunity for us to reduce legal uncertainty and prevent regulatory fragmentation, because we see that when the Commission is not acting, several member states go ahead and adopt national laws in some of these fields. We also see it as an opportunity, which I'm sure will be of interest to you, to make sure that we ensure consistent application of our horizontal consumer law framework and the broader EU digital rulebook that is out there and on which we receive several questions. And of course, one element that I know BEUC has also been emphasizing systematically, an opportunity to ensure better enforcement of the laws that are in place, because we see that the ambiguity that is there at the moment prohibits often consumer protection authorities from taking the step to protect consumers in practice. So these are the elements that we seek. On top of that, of course, I will underline the opportunity for further simplification. As you know, competitiveness is an overall objective of this Commission that we take very seriously. And in designing the Digital Fairness Act and its impact assessment, we will, of course, seek possibilities to make the rules not only clearer, but also more straightforward, if possible.
Great. Thank you so much. Simona, already back in 2023, the European Parliament had adopted a resolution in which it pointed out that addictive design is not sufficiently covered by EU law. Could you maybe give us a little overview what is meant by addictive design, how this is harming consumers, and in particular, why it is not sufficiently covered by EU law?
Yes, definitely. Can anybody hear me? Yes, I think so. Okay, so in 2023, we started writing a report in the European Parliament on addictive design of online services. And we started as a general, it started as a general feeling of worry and annoyance, because we spoke to lots of parents, we spoke to lots of youngsters who were all very much concerned about the loss of control they experienced over their use of smartphones, of apps, or they saw their children lose over the smartphones and apps. And a lot of the time, we especially hear this narrative in the context of protection of minors, which is very important, and we see the large impacts on children, but also parents no longer being present when around their kids because they're constantly on their phone or distracted by their phone is an equally big problem for children. And so we started working on this report and started the research, and what we found was absolutely shocking. First, there was already research from the European Parliament that said 1 in 4 youngsters displays problematic smartphone use, which is basically behavior that has symptoms of addiction in it. We discovered that youngsters, young adults between 16 and 25 spend more than 7 hours online on average, and many of them indicate they have this feeling they've lost control over it. So it's not just like, oh, youngsters will be youngsters and let them be. They have a feeling that it's no longer in their hands and they're being controlled by these devices and their urges to go on it. So then when we looked into this further, what are mechanisms that keep people online? we found out that you can quite specifically pinpoint mechanisms that have been designed. I mean, it's not coincidental that platforms are very addictive. These have been very strategically and carefully designed to keep you online. And I think that is a very important point to remember. And we found out that, for example, the ones everyone will recognize, the automatic playing of videos when actually you weren't even planning to look at it, but there's already moving images in front of you and you stick to it. Endless scrolling without an end, while newspapers, books, etc. all have an ending of an article, an ending of a moment, and we just can keep scrolling as long as we want. And we found that these are in any case the most pertinent and harmful ones. But also there are lots of questionable dynamics that we would have to look into more deeply. For example, the whole construct of likes and what this does in terms of gratification for people, and actually really gives you an impulse of dopamine in your brain. So these are some examples of addictive design features, and also like ones that you haven't necessarily thought of before. For example, is typing on messaging apps. I always thought, I'd never questioned it, but then one of the experts told us, yes, why do you think that's there? You can get a notification if someone's responded to you. No, it's so that you stick there and continue looking at it. And what was most worrying is that we saw a lot of harmful effects, especially on the concentration span. I found very shocking. In the Netherlands, we see, especially in the city of Amsterdam, they have data on it. They see kids coming to eye clinics at a very young age because it distorts the development of the eye, the amount of screen time they're getting. And, well, of course, that is a lot to do with parents too, but it's natural that kids are just glued to their screens if you put a screen in front of them. And so attention span, physical development, mental health issues, which are really severe, depressions, anxiety, bad image of themselves, and also just general distraction, poorer results at school, etc., just because youngsters, but also adults, are glued to their screen. So all in all, the research was very shocking. We also, of course, looked into the legal implications. And something I hear more and more, especially from industry corners, is, yes, it's already covered by the DSA. We looked into that as well, and our conclusion in the report too is it's not. And I think there we can also be very simple. The DSA says it covers dark patterns insofar as the Unfair Consumer Practices Directive doesn't. So the UCPD has primacy over this, and that is exactly what the Commission is going to revise at the moment. And then the Parliament very clearly, with really an overwhelming majority, voted in favour of this report to ban the most harmful addictive practices online and greylist the ones that we presume to be addictive and harmful. And I think banning things via guidelines under the DSA is very shaky. I'm legally trained. I think banning things via guidelines is more shaky than if we now agree on clear provisions in the Unfair Consumer Practices Directive that actually provide guidance to business, enough guidance to business, make it clear enough also for consumers to act upon. And I'm very sure that we will have a good cooperation on this in the future of our work on this.
Thank you very much, Simona. Ilya, two important findings of the fitness check were that the enforcement of EU consumer law is insufficient. I think the term was insufficient. And also the fitness check report pointed out that there's an increasing regulatory fragmentation because member states have started adopting national rules to address the problems, some of which have been identified in the fitness check. So what's your view on these findings, and do you agree that enforcement of consumer law should be improved, but also do you agree with those findings that the single market is increasingly fragmented by member states, by national rules?
I think it's then good that I'm also in charge of single market as Eurocommerce. I can say something about that. So maybe just for people in the room, Eurocommerce, we are the European umbrella organization for retail and wholesale companies. So we have members in all European member states and some other European countries, so in national associations, but also companies can become a direct member. It's food, non-food, online, offline. So it's really the entire sector, and we are with there are about 3.5 million retail businesses in the EU, of which 99% are SMEs. So I think I agree with the fact that there is not enough enforcement of consumer law, maybe EU law in a more general sense. And actually, we did together with 2 other European retail associations a joint study because, I mean, this is a very broad topic, right? Digital fairness. We were just talking about addictive design. There are some other issues mentioned on minors. In retail, we are resellers of products, right? So we are usually not the producer, but we resell products that others have produced to consumers. So in this context, we looked like, okay, what do we see? What are people saying? What are the complaints about? And so we looked, for instance, at a report of the Consumer Protection Cooperation Network. So that's basically the network of national consumer protection authorities that work together at EU level. We looked at the work of the European Commission, but we also looked at the work of BEUC, of the European Consumer Association. And then we looked at, okay, which practices would occur in online retail? Because this is what we are talking about. And there actually, what we did, we had university professors helping us, and they looked at these practices and then checked, okay, if you would like to address those practices, is it already possible today based on current EU rules? And actually, in most cases, it was. But the rules are not enforced properly. Obviously, there can be different reasons for that. Sometimes it's about expertise, it's about resources, it's about maybe clarity of the rules. It can have something to do like how do you, maybe when you find an infringement, how do you actually handle it afterwards? But I think this is a big issue for us because in ours, we feel is that sometimes maybe we're asking for new rules just because the current rules are not well enforced. But if we cannot enforce the rules that we have now, will it really change something? So I think this has to go hand in hand. And I think we see, some merit that there might be in certain occasions that a targeted approach will help to solve certain issues, will clarify certain issues, but definitely not like an overhaul of horizontal consumer law. We think that's not necessary at this stage. And maybe to add, we're also working with BEUC on looking into a joint statement to actually push for a quicker review of the Consumer Protection Cooperation Regulation, because we feel this is a unique opportunity for the Commission to come up with a proposal that can improve enforcement of EU consumer law, because that is what we want and that is what we need. And maybe attached to that, because in our view the issue is broader, we also launched a campaign last year on a level playing field where we see unfair competition from third country marketplaces and traders. So we see a lot of non-compliant products entering the EU market, but it's not only about product safety, it's indeed about consumer protection, but it's also about data protection, right? I think there are now a number of complaints against Chinese platforms for processing data of EU data subjects in China. So this is really happening. I mean, there has been a fine, I think, recently as well. But it's also about customs, right? So how do we check our borders? So I think in general, I think there are a lot of issues that actually might undermine the safety of consumers, and they all need to be addressed, including this one, I would say. On the fragmentation, yes, this is a real issue, but also at the same time, member states fragment the rules, but we also allow it to happen at EU level. And I think a good example is the initiative on repair, which was adopted 1 or 2 years ago, where actually you have a legal guarantee of non-conformity, which is minimum harmonization at 2 years in every country, but countries can go beyond. And you know what they did? They also now put in the law that member states have now a minimum after repair, you get an additional minimum guarantee period of 6 months, and you can go further. So actually now you have a situation where you have a legal guarantee and an additional guarantee after repair, which are both minimum harmonization. And it was not necessary, in my view. It was not necessary to put in a law that member states can do whatever they want. So I think it's also important to look at how do we organize the rules here. And this might also be an interesting element for the simplification part of the Digital Fairness Act. Thank you.
Thank you very much, Ilya. Fritjof, what's your view on the findings of the fitness check? Has the fitness check identified all the relevant problems that consumers face online, or is anything missing? And what's your view on enforcement? Do you think it will be enough to improve enforcement to address all the problems that have been identified, or is there more that we need?
Yeah, thank you. Maybe let me start by saying that basically all consumers are concerned by unfair practices online, because we have, like in France, we have 90% of consumers who have a smartphone, 70% of people who play video games. Basically every TV, every car you buy today is connected, so we shouldn't forget those devices either. And so you actually have consumers who use online services and are not even aware because the devices are connected. We often get asked by authorities when we present them with our findings about unfair practices, oh, that's really interesting, do you get many complaints from consumers? And the answer is very often no, and complaints are really not a good indicator when it comes to digital services. In some other areas, yes, but here the problem is that for consumers, well, there are several problems. Consumers, when they experience unfairness online, often the services they use, they don't pay for them. They pay with their attention, with their data, but not with money. So it's not worth for them going through any proceedings to highlight, to signal this, to notify the practice, because they don't get anything out of it. And we also have an important number of people who experience at least some level of digital literacy. In France, it's at least 25%. So these are people that, even with fair design, they at least sometimes struggle using digital services. You know, we never have a consumer coming to us telling us, oh, I went to this website and then I spotted, I know, confirm shaming and a roach motel and nagging. These are concepts that they don't know. They don't know how to express that. But what they still feel and experience that unfairness, and that's actually why the DFA, Digital Fairness Act, it's a really good name, this unfairness. And we see this a lot. Well, the Fitness Act shows us, of course, 97% of websites have dark patterns. So there's real proof that these practices are everywhere. And for consumers, it's very hard to conceptualize this, but they feel this. And there are many studies showing this, the EP report, the fitness check, of course, studies that we do as consumer organizations, the consumer conditions scoreboard. There's so much evidence showing how the trust in the digital environment is eroding. The fitness check is really, I mean, it's really great. We've been waiting for it for 2 years for it to come out. And when it finally came out, we're really happy with it, because it really covers a lot of the things that we've experienced for many years, that consumers experienced, that we've shown as consumer organizations for many years. So really, I would really congratulate the Commission and thank them even for this great work. And there are many people who disagree a bit with, or many, but some stakeholders that disagree with the political plans of the Commission and DFA, but I haven't seen anyone disagreeing actually with the fact finding that was done. So that's really important, I think. So there's really consensus that the issues are really big. You mentioned enforcement also. Yeah, I think that's of course crucial. I would even go a bit further in saying that enforcement of the rules that we currently have in the digital sphere, it's a complete failure actually, because consumers don't do it. As I said earlier, for them there's no point because they don't get anything out of it. us as consumer organizations, we try doing it, but it's very difficult, it's expensive, it takes many years, and in the end you get a decision against one trader about one particular practice. That's super ineffective, and we are facing a lot of like systemic practices here that are everywhere, so we cannot just do individual cases to solve these issues. And then there are also practices that you simply cannot prove them. Basically, whenever there's an algorithm involved, as consumer organizations, but also as the consumers who experience the unfairness, they have no means of proving what's actually going on, what the digital service is doing. So it's clear that the DFA, it will fail if the issue of enforcement, public and private enforcement, if that issue is not solved. But that being said, I think it's if you see all this evidence that there is, I think it's a bit starry-eyed to believe that the enforcement will solve all these issues, because there's so many areas that are, and that's shown in the Commission's work, that are not covered by the existing legislation. You have addictive design, personalisation, online advertising, loot boxes, AI services. There's so many things, and there's no way that the DFA can properly tackle unfair practices online if it does not also, in addition to dealing with enforcement, if it doesn't also add new substantive rules on all these areas that are not covered today. And there's so many that today we really only have the time to talk about a fraction of them, and the DFA will have to deal with them in a substantive way.
Thank you very much, Fridtjof, for this very clear statement. Mr. Now, I would like to come back to you, and since Fridtjof already mentioned the Digital Fairness Act, I would like to invite you to maybe share with the audience what plans you have for the Digital Fairness Act, what topics you are considering to address, and maybe if you can already share like how you're considering to address them.
Well, thank you very much, Urs, and I should also thank very much my fellow panelists, because I think the breadth of issues they have raised only in these introductory statements shows that the work ahead of us is really very, very significant. I appreciate also the fact that the fitness check is a starting point. Happy to hear that it's a good starting point. But of course, as I said, we are also in a phase where we are consulting, we are gathering further data, and we rely on all of you to perhaps point to certain areas that we haven't fully captured. Now, as you know, the core content of the future Digital Fairness Act, what we will be looking at during the impact assessment phase, is already quite well known, because both mission letters for Commissioner McGrath and the Executive Vice President Virkkunen spell out, let's say, what we consider the 4 core areas, and these we have already mentioned. So when it comes to dark patterns, there indeed, as was already hinted, what we will be looking to do is to see whether we can further clarify and concretize what are currently principle-based rules on unfair commercial practices to be better adapted to the digital environment. To put it bluntly, do we put black on white, this practice is a dark pattern, it is prohibited. How we will do it, we are still reflecting. It can be an update of the UCPD so-called blacklist. It could be standalone provisions. This is part of what we seek to find out during the consultation. When it comes to addictive design, and there Simona illustrated very clearly that the problem is still very present, very, very pressing. What we will be examining is options precisely to give users more effective control. So a real possibility, for example, to turn off such addictive design features. And I should point out at this point that we also get a clear message that the bar needs to be even higher in this regard when we are talking about children, when we are talking about minors. The draft report of the European Parliament on the protection of minors was just published, I believe. And there is a clear call, for example, in it for the Commission to consider banning addictive features with regard to video games, loot boxes, in-app currencies, pay-to-progress methods. So this is something we will be looking at. The precise decision we will take, of course, will rely very much on the feedback that we get during the consultation phase. On unfair personalization practices, there, as I hinted at the beginning, we are not seeking to stop personalization. We acknowledge that consumers often appreciate having offers that are better tailored to their interests and needs. But again, for us, it is an issue of control, and it's an issue of making sure that consumer vulnerabilities are not exploited. One example we often mention, and is also included in the report of the draft report of the European Parliament, regards the prohibition of targeted advertising towards minors, where we already have a very clear rule in the Digital Services Act, but we see perhaps a value in looking into extending it to other types of online traders. Then when it comes to influencer marketing, again, for us, this is a possibility to clarify rules as regards their responsibilities, but also the responsibilities of the brands and companies that engage influencers. This is an area where we really see a clear risk of fragmentation, because several member states have stepped forward with laws at national level, and we want to make sure that we keep the level playing field. Then, when it comes to digital contracts, I mentioned before that one of the complaints we are consistently getting is consumers saying that it's very difficult to cancel. So from our perspective, it should be as easy to cancel a subscription as it is to enter into it. We will be assessing options such as an easy click to cancel button, for example, or other variations. This, let's say, is the general framework. Of course, I could talk long about other things that we are considering in the context of the DFA, and I hope that when the public consultation is out, you will see that there are other specific aspects that are tackled, for example, in the fitness check, that we follow up on with specific questions. But perhaps one last word on the question of enforcement, because this came up very, very strongly in our first round. On the perspective of from the perspective of the DFA, where we feel we can contribute to better enforcement is precisely through greater clarity of the rules, making the rules specific enough while keeping them principle-based, so that they can be used in front. Of course, they can be used by consumers and private enforcement. But this is not the only thing we are doing in the consumer protection area. You referred to the review of the consumer protection cooperation regulation. For us, this is a track that we are also exploring. Yesterday we had the Consumer Summit, and I have to say the messages were very strong. Commissioner McGrath took a clear stance towards the need to look further also in updating that part of our consumer acquis. So we will be taking this feedback very seriously moving forward, and we will, of course, try to ensure that the two processes communicate with each other and are coherent with each other. Last message for me is that it's not an either-or. It's not that we either enforce the rules that are in place or we update our consumer protection framework from a substantive point of view. We need to do both in parallel if we want to guarantee a high level of protection.
Very clear message. Thanks so much, Mirto. Simona, coming back to the resolution on addictive design from 2023, I think in that resolution, the Parliament pointed out that personalization may be used to manipulate consumers. Do you think it's enough to address personalization as an angle of addictive design? Or, as Mirto pointed out, do we need to address personalization per se?
I think personalization can be a very big element of addictive design, because not only do you get faced with features that are designed to keep you online, but also because they're targeted to you in a very personalized way, they can be specifically addictive to you. And I think that there is a very important part of addictive design, but definitely we see issues that are broader. We see personalized pricing, where we have a huge problem. In ticketing for concerts, for transport, for all sorts of services and goods, you go online, you see a price, you think about it for a day, you go online the next day, and because they've registered that you were looking at it, the price suddenly shoots up. And yeah, I think these kind of practices are also really unfair. Also, up until now, it's been quite ambiguous. In the previous mandate, we did hear some whispers about the cookie pledge, the voluntary initiative on cookies under DJ Reinders, commissioner, didn't go as well as hoped. That maybe it's time to take action on those kind of practices too. And there, I think everybody knows the cookie banner and how annoying it is. I think it's even a source of, among people, great frustration. So it's like, yeah, the EU made us put these cookie banners here, and it's really annoying. And that's also something I would like to warn for in the unfair consumer practices, or review the Digital Fairness Act, etc. That if we allow for practices to be turned off, then first consumers have to go through a cookie banner, off, toggle, toggle, toggle. Oh, no, I didn't manage to turn them off. Okay, again, okay, damn it, accept. And then they'll have another screen toggling off, or the addictive practices too. I would really say at least consider the turned off by default and turn them on if you want. If you want a more vibrant scrolling and just want a couch potato for an hour and scroll as much as you want, okay, then we can maybe think that's up to you. But at least make ethical design the default. And I think there too, I mean, I've now told about all the things we shouldn't do anymore, but I think there's also a lot of work for us all to look into what are ethical design practices. How can you make a marketplace, a social media platform, a dating app, a video streaming platform, still user-friendly, fun, easy to use, but with the user in control. And that's also something we'll be working on a lot. And maybe a last one there is also the transparency that consumer law kind of it departs from the principle that a consumer, if they don't like a product or a service, they can switch to another one. And they can say, no, this is unfair, I'm going to move. But in the current digital sphere, we see that you don't actually know what's going on, which makes it really hard for consumer organizations and consumers themselves to challenge. It makes it, well, very difficult for consumers to pinpoint and switch. And I think transparency is another really important part of that. And also on the personalized pricing, etc. Now too, there we have no clue what's going on. We see a price shoot up. We have no clue why. You're just faced with a more expensive price, and often you just have to deal with it. And yeah, I think there's lots of scope to improve that too, not only in the face of addictive design.
Thank you very much. Ilya, one of the findings of the fitness check was that there's a lot of uncertainty as to how consumer law applies to various practices. And I think Friedhof also referred to this problem. Do you agree with this finding? And if so, what would be your recommendations how legal certainty could be improved?
Yeah, so I think already a lot has been said, which I think I also want to reply to. But I think on the question of legal certainty, I think on paper, I think consumers have legal certainty. But I think in practice, it becomes difficult, right? Because this is what we're discussing here. I mean, enforcement is not working properly. And not saying anything about, I mean, there are certain, I think, issues that need to be addressed. But if we don't enforce the rules that we have, then you can also not provide the legal certainty that is necessary. And I think actually it was very interesting what you said earlier, because one of the things that we are saying is EU law lacks enforceability. So we are very well at designing rules, but we don't think through how we're going to enforce them on all players that are active in the market. And I think this is why we have some of these problems now also with, the unfair competition from outside the EU, because we can enforce the rules here. If a company does something wrong, it is in the territory or, of an authority. But if that company is not here, then it becomes very problematic. And I think this really should be part of the impact assessment of any new future EU law, that we look at the enforceability. Because if we cannot enforce the rules, then why are we enforcing them? And actually that leads to a situation where here in Europe, players try to comply with the rules, and that has a cost. And if your biggest competitor in your market doesn't do that, you actually increase the difference between what is compliant and what is non-compliant. And you actually make it more attractive for consumers to make the wrong choice. So I think we really need to be careful about that. Then I think there is this issue about trust. So we just had the consumer conditions scoreboard, and 70% of consumers trust that what retailers offer them is okay. And actually that's higher than the trust in NGOs or in public authorities. And 70% is maybe not enough. It just means, we have more work to do. But I just wanted to point that out. So then we had the issue also about personalization. I think you said it very well, Myrto. It's about unfair personalization. Personalization, it's what consumers want. I mean, when we talk to our company members, they say if we don't offer more personalized services and products, we're out. They just don't come to our websites anymore. So I think we really need to be clear about what we're talking about, right? We're talking about the unfair part, but consumers want personalization, and they want it more and more and more, and for that, you need to have more information about your consumer. So, and I think the issue on personalized prices, I can imagine this may be an issue in other sectors, I don't know, but for retail, if you go online, you look for a product, I think you get 5, 6, 7 different offers immediately, and you choose probably the best price that you can find. So I don't think in retail you would find yourself in a situation where the next day the price is higher, and if it was, well, you just pick another one. I think you have enough choice to go somewhere else. So I think it's important to see that. And I think also the issue of cookie banners, that's enforcement. Because it should be as easy to accept as to reject. So if you go on your own website and look what you've done. So if it's more difficult to reject than accept, you're violating the rules, right? So instruct all your colleagues and say they have to do it better. And that also I have to do that, by the way. But I just want to point it out. And obviously, but maybe this rule is just not enforceable because there's so many websites and so many cookie banners. Like, how did you do this? But then we go back to the point of enforceability. Like, okay, we have a rule, but can we enforce it? Does it make sense? Yeah, I think I'm going to stop here. I also want to give you the floor, so thank you.
Fridtjof, you heard Myrto's announcement regarding the DFA, the different topics, and how they are considering to address them. What's your views on these announcements?
Maybe since we're running a bit out of time, I just respond to one, which is what Myrto mentioned about the children protection, which I think is very important. Of course, as all the other topics, there is so much evidence, and there's more and more evidence being produced about the impacts on children of unfair online practices. This is something that must be really carefully done when it comes to actually making the law. And for us, the big elephant in the room is really this question of how do you make sure that it works for children and also for the adult users and also for the businesses, of course. There's this panacea of age verification that's been promised by some we don't have it yet, but it will come very soon and will solve all these problems. we are very skeptical for several reasons. We don't see how these solutions can properly reconcile privacy and effectiveness. Obviously, young people have amazing capabilities of circumventing such tools. And then there's, of course, the question of enforcement. Again, how do you actually enforce this, and how do businesses do this? Also, in the sense of simplification, it would basically mean that they would have to have two interfaces, one for children, one for adults. But at the same time, they're not supposed to know whether the person using the interface is a child or an adult. So how do we solve these issues? For us, we have the tendency to say that in many cases, well, I'm not saying that we don't need specific rules for children, of course. There are some things for content, for example, it makes total sense because you have some content that is harmful for children but not for adults. When it's about unfair commercial practices, it becomes really difficult, and we have more the tendency to say that the easiest way to keep the online environment safe for children is just to make it safe for everyone. Because many of these practices, they are, of course, particularly harmful for children, but they're also harmful for adults.
Thank you very much, Friedrich. Very clear statement. Now I think it's high time to open the floor for our Q&A session. I have my colleague Mayant with me who will take the microphone to go around. So if you have questions, please raise your hand, state your name and affiliation before asking your question. And please keep it short, given our time constraints. We're going to collect a few questions and then invite the speakers to answer. So please.
Hello, thank you for this very interesting panel. I'm Julien Rossi from ISOC France, and I also work as a researcher. I have a question about something that I feel would deserve maybe more attention as a proposal in all of this discussion. In conducting different research projects, we have noticed that especially young people often tell us that they actually feel that they are compelled to use even toxic digital environments by adults, including public institutions. I'm thinking of schools. And in the process of digitizing every sort of public service and forcing people into using digital solutions to interact with fundamental public services, very often what we find is that public authorities are actually forcing people into these toxic online environments. A lot of times those digital apps that are forced upon people are also exhibiting dark patterns and things like that, and they're forcing people to use their smartphones all the time and so forth. So my very simple question is, have you considered the inclusion of a right to opt out of a toxic digital environment, which basically amounts to a right to be offline, at least with regards to relations with public authorities and access to basic public services? Thank you.
Okay, very good question. Thank you very much. There's a gentleman on the left side in a white shirt.
Okay. I'm gonna.
Good afternoon. I'm Maris Rukers from Latvia. I'm a practical privacy lawyer. I have a comment or issue concerning minors. You mentioned a lot. As we know, if we see the car on the road, we presume that people are driving at least from 18 years. We don't presume that the child is driving in the car, conducting the car. And we know that the GDPR has this consent age. It is 16, and some countries made it lower. For example, in Latvia is 13 years. A child can make consent. And the second aspect is that child also cannot conclude contracts as consumer from the certain age because he don't have a bank account and legal capacity to enter into contract. And the issue is in this Digital Fairness Act project, can we just presume that child under certain age cannot simply be a consumer and he cannot simply hold the phone legally, but if he do, then it's not possible. And if the phone will get more applications and functions. For example, now it's AI, etc. Could we just, after 10 years, we'll come to the decision that, as with the cars, child could not simply hold the phone. It's not possible, not legally and not physically. He cannot hold the phone because already in the schools it's banned somewhere, etc. So how are you seeing this aspect? Thank you.
Thank you. Then the lady on the second row here.
Yeah, hi, Anupriya from Euractiv. I had two questions. The first one on minors. We've seen that several member countries are asking for a ban on social media called a digital majority age. For example, France and Spain is asking for a social media ban under 15, I believe. What would be the Commission's thoughts on that? Also, on the DFA, would we see a separate level of protection for minors and, let's say, non-minors? Is that already something the Commission is considering? Then on simplification, very quickly, what does that practically mean for the DFA? Does this mean that we're looking at lower ambitions than what was originally conceived? Will we see a set of guidelines which were supposed to originally be directives or etc.? So what would simplification practically mean on consumer law? Yeah, thank you.
Thank you very much. I think we'll leave it here. And I think most of the questions, if I'm not mistaken, to maybe going your direction, but please.
I'm sure others can comment as well, because I think the issues are broader, but happy to offer some first reactions. First of all, as regards this right of consumers to opt out of digital solutions overall. I mean, first of all, I'm not best placed, and it will not be through consumer law that we define the relationship when it comes to public authorities in particular. This is not the scope of what we're looking at. But it is also true that even in business-to-consumer relations, we often have people, representatives of vulnerable groups in particular, advocating for offering consumers also an offline option, for example, when it comes to information requirements. It's not a new question. It's one that we have been faced with for a long time, but it is also true that there is a balance to be drawn. The reality is out there that our life is moving to the digital sphere more and more. There are essential parts of consumer law when it comes, for example, to product safety information, where we see a clear value in also keeping information offline. But the focus of the Digital Fairness Act will be, let's say, to regulate and clarify rules when it comes to the digital environment, the presence of consumers online. Then on the question on the age, let's say, of users and whether we can overall, let's say, protect, exclude children from online transactions up to a certain age. First of all, I should say I also have a very good Latvian practicing lawyer in my team. He's my deputy, so I can very much invite you to continue the discussion with him, because it's very, very interesting. But I should say that from our side, we are also listening to those voices who say that the digital environment is a place where children need to be familiar with. You cannot expect that consumers will, that children will only start being consumers after they're 16 or after they're 18, because the reality is a lot of them are online, a lot of them are digital natives, early adopters of technology, and they do engage in these types of transactions. So while we are looking at age assurance and age verification as an option, because this is something that from a technical perspective our colleagues in DG Connect are exploring, and we have stakeholders advocating that these solutions can be embedded also in consumer protection legislation. Our objective is really to raise the bar, raise the safety net, as I was saying, overall for all categories of consumers, also knowing that very often these types of prohibitions can be easily circumvented. So yes, maybe a minor does not have a credit card, but very often they have the authorization of their parents, sometimes even unknowingly, to go online and complete this kind of microtransactions as part, for example, of an in-app purchases or an in-app purchase or an in-game purchase. And we have seen cases where this accumulates to very significant amounts spent. So from our perspective, what we want to make sure is that we close as much as possible the loopholes. So far, we have not, let's say, looked into the possibility of a complete ban of minors from the online environment. But of course, there's a consultation coming up. So you're free to contribute all types of ideas. I think that answers also, to some extent, your question from the side of Euractiv. When it comes to whether we are looking to create a separate category of protection for minors under the Digital Fairness Act, again, it's a time when we are consulting. So far, for the reasons I just explained, what we are perhaps considering is creating certain rules that go further when we know that the consumer in question is a minor, but not to create, let's say, a separate category of rights that only exclusively apply to minors. And then on the question on simplification, for me, I find it entertaining that you would say, is this lowering the level of ambition? Because there's nothing easier than piling up legislation, and there's nothing harder than making the rules simpler than they are, but keeping the level of protection high and effective. So really, simplification is for us a challenge, but one that we take very seriously. It's not about lowering ambition in terms of not going for a legal proposal versus soft law. This is something, again, that we will consult on, and if at some point we deem it's more appropriate, more effective, in some areas not to legislate, but to provide guidance, we will. But the truth is, this is a legislative initiative, and that is what we are consulting on. To offer some concrete examples, you can look also at the findings of the fitness check. We saw, for example, that when it comes to information requirements in cases of repeated in-app purchase, perhaps there is a scope to simplify the obligations for traders there. Another area that has been brought to our attention is the exercise of the right of withdrawal when it comes to digital subscriptions, especially for audiovisual content, and what happens, let's say, when a consumer stops their subscription and have already consumed part of this audiovisual content. Right now, the rules seem to be quite hard to apply in practice. So these are the types of issues we will be looking at, but also we are opening the floor for more areas that perhaps offer themselves to simplified rules.
Thank you very much. I think, conscious of time, we can only take one last question.
I will not answer it then. I will give the floor to somebody else.
So in the first row.
Go.
Sarah Brandstetter from MLEX, specifically to the Commission, but I guess interesting for everyone. Can you explain a bit more how you will address potential overlaps with other laws? So the DSA, we heard a bit about it with addictive design, or also the AI Act. This is something that has been raised a lot by industry, and I know you did the digital fitness check, but also now in the future, how will you practically address this issue?
Should answer.
Yeah, please.
So Indeed, that is an issue that we're taking, that we're approaching very carefully. Commissioner McGrath has said many times that the intention of the Digital Fairness Act is not to reopen or duplicate issues that have been recently regulated. We see the Digital Fairness Act as a possibility to clarify the interplay with the Digital Rulebook and the Digital Services Act in particular. But I should also remind that there is a process ongoing, also managed by our colleagues in DG Connect, on a report on the overall interplay of the DSA with other areas of EU legislation, which will also cover consumer law, and there we hope that we already can provide some clarity. So I would say for us moving forward, what we are looking to do is, in some cases, as I mentioned, for example, when it comes to the protection of minors against targeted advertising, the DFA could extend rules that are already part of the Digital Services Act, but we feel merit to be applied in broader categories of traders that do not fall within the scope of the DSA. Then, of course, it is also an opportunity to clarify areas where we have a clear interplay and carve-out. I'm talking, for example, about Article 25 on dark patterns, where indeed we have a specific mention of the UCPD and the GDPR. And as far as the Unfair Commercial Practice Directive is concerned, we see now an opportunity to clarify more clearly which types of dark patterns are covered.
Thank you very much. I think we have to come to our concluding round. So now I would like to come back to our speakers, and this time I would like to change the order and start with you, Fridtjof, and then continue with Ilya and Simona. And I would like to invite all of you to present your main recommendation, one main recommendation for the way forward. And then finally, I would like to invite Mirtu to maybe respond to these recommendations and outline a bit the process that lies ahead of us until the DFA proposal comes out. So, Fridtjof, please.
I would have a very broad recommendation. I think there's now, this general atmosphere of simplification, competitiveness, and also a lot of talk, even from us as consumer organizations, how the Digital Fairness Act can also contribute to competitiveness. But I would just like to recall that competitiveness is not the objective of consumer protection law, obviously. It can be a side effect of that, but it's not the objective. And the DFA, the success of the DFA, it will be measured not by how well it boosts competitiveness, but how well it protects consumers.
Thank you very much, Ilya. Your recommendation for the way ahead?
I'm also going to abuse this because about some of the questions that were said. I just wanted to say about the simplification part. At this moment, I said earlier, 3.5 million retailers are there in Europe. 99% of them are SMEs. They don't have the capacity to understand all the rules that are there. And then if we change them every few years, this is impossible. So you need to also help these businesses to be compliant. And I think at the same time, if you look at consumers are not aware of their rights. So it's also, if we don't help consumers to understand what their rights are and how they can get redress, the system also will never work properly. So I think we need to take that into account. And I have to say to the person from Latvia, I wanted to say enforceability. That's what I said earlier. So if we want to ban minors from being consumers, how are we going to enforce this? Is this enforceable? And who are we going to fine? The parents, if they are online. So I think really this is an important thing to think about. So maybe, on certain aspects, there might be merit in doing something like this, but at the same time, this is a rule you cannot enforce at all. And I think that's also basically maybe my recommendation is really we need to be able to enforce the rules that we have, and we need to be able to enforce the rules that we want to have. If we cannot do that, basically we're lying to everybody. And in a few years' time, we will have the same discussions, we will have the same problems. And the only thing that has changed is that businesses here in Europe have to comply with more rules and will have more costs. And I think we need to prevent that from happening because it's also not fair towards consumers. Thank you.
Thank you, Ilya. Simona, please.
If I can only do one recommendation, I'm going to go back to my cause. I'd say tackle addictive design strongly for everyone, like Commissioner McGrath promised us in his hearing, and with the level of ambition, because I know it's not easy in the deregulatory atmosphere at the moment and with the pressure coming from the other side of the ocean. But I think here the EU really needs to stand up for how they decide over their own businesses, their own people, their own territory, and really have the right level of ambition to protect people in the EU and provide the clarity to allow for the enforceability that we need. And I really think this could be one of the big success stories from the EU for future generations if we get it right.
Thank you. Myrto, please. No. Sorry. Oh, yes. Okay, please.
Yes.
Yeah.
I have to say, I find myself in an easy position because I feel that at this stage, all the issues you raise are also objectives for us at the European Commission. So when it comes to the purpose of this Digital Fairness Act, of course, first and foremost, it's the protection of consumers. I said it at the very beginning. We know that this protection is not at the level that it needs to be in the digital environment. There are gaps, there are areas of legal certainty, and we seek to keep up with technological developments for the protection of consumers through this act. That being said, it doesn't mean that by protecting consumers we are harming EU's competitiveness. I would even argue conversely, by raising consumer trust, we are contributing to a more competitive digital environment in the EU. Then when it comes to simplification, like I said, it is one of our priorities through this initiative. Help us get it right by contributing specific suggestions. I was only able to touch upon a couple of examples, but if there are other areas of our consumer law where you currently notice concrete burdens for companies, where rules could be simpler, we will consider this seriously. I should, however, point out that one of the findings of the fitness check that is often overlooked is that companies themselves, and I'm talking about companies of all sizes, speak about consumer law as one of the areas where compliance costs are very low. We don't have big requirements. We don't have reporting requirements. We don't have ex-ante risk assessments. It's really mostly common sense rules, and that's very much the approach that we want to keep for the Digital Fairness Act. And finally, message loud and clear. The promise has been given from the Commissioner himself. So, of course, we will look to tackle addictive design features in an ambitious way. And overall, I want to promise you, Urs, we will keep the level of ambition high. We know we can be both ambitious and pragmatic in what is a complex regulatory field.
Excellent. Thank you so much. I think there's, as the discussion has shown, so much to discuss. Maybe we can meet again next year at the CPDP to continue this conversation. But I think for today we have to close the panel, and I would like to close it by thanking, first of all, the CPDP for hosting our panel. I would like to thank all of you for coming and participating. And of course, I want to thank our wonderful speakers, Myrto, Simona, Ilya, and Fridtjof. Please join me for a round of applause.